interested in learning more about how to protect proprietary information and exactly what is considered proprietary information.
So I think we're going to talk about that in terms of trade secrets, things that you might want to just kind of hold close to the vest. But if we don't cover something you specifically want to know, feel free to ask. How about you?
They have kind of covered it. I'm also an artist, so I have that idea of, how do I protect my things, including like things you would put up as far as like you generate a meme or you put out an idea or design a course. So.
Okay, I think we're going to cover all of that.
Yeah.
But again, if there's something that I don't cover that you want to know, jump in if you think, wait, she's moving on and we haven't got to that. And how about you?
Yeah, I head the finance department at the airport for International. We have a trademark that occasionally comes up. I see a bill or something, and should I pay this bill? And the attorney says, no, I'll let you know when you gotta pay something. So it's a dynamic between lawyers and accountants. Neither of us really trust each other.
Oh, dear.
So
Okay, well, I'm not going to get into that debate.
Mediation might be better.
There's a cartoon. Okay, are we recording yet?
Yeah, but
All right, that's okay.
No, I'll cut it
So
out.
this is a pretty famous cartoon, actually, and I used to see it. I started in the office in 1989, and there's a cow, and there's one man pulling the head, and the other man pulling the tail, and there's the client or the patent in the middle, the patent applicant in the middle. So the the attorney's kind of fighting with sort of taking advantage of the situation.
So I guess I want to know more about the trademark maintenance.
So trademark maintenance, that's interesting. So you all know, one of the things my office handles is scam prevention. I own my own trademark also, and I've worked in the office since 1989. And once my trademark issued, just as if anybody else gets a trademark, you have to put your address on it. I don't know if you can use a post office box, but then it becomes public. And I started getting unsolicited mail from organizations that looked very official, like Patent and Trademark Institute, or something with those words in it, and a bill, like that, or it looked like a bill. And I was like, what is this? Am I supposed to pay it? And I thought, I figured out that it was somebody trying to get me to pay it to sort of automatically sign me up for a service that they would or would not provide. And I thought to myself, well, gosh, if I have this hard a time figuring out what that really is, and I work in the office, I don't know how people who don't work in the office and aren't really familiar can figure out what's real and what is somebody just trying to get money out of them. So there's a lot of that going around, especially on the patent side, but for sure on the trademark side also. So I'm not saying that that's what you got, but
Well, probably it is, but it looked really official.
it looks really official. They're so clever. You just think to yourself, if some of those scam operators put their minds to a legitimate business, they're so good at scamming. They could be really great at something legit also, because they're good business people, great marketing material, super good branding, because it makes you think that there's somebody legit. But okay, so I'll let you.
Well, it's okay.
Kick
Well,
your,
so, I think I know just about all of you in the room, and I think I introduced myself to those that I didn't know. I'm Karen Groh, I'm the President and CEO of the Chamber of Commerce, but I am also the Board Chair for the Center for Entrepreneurial Excellence. So the Chamber of Commerce is a membership-driven business organization to help business in the Lebanon County area. The Center for Entrepreneurial Excellence is a free service to anybody in Lebanon County who wants to come in and utilize the services for support, mentoring, workshops. There's a lot of resources in here. And we just want to make sure that entrepreneurs in the Lebanon County know that there's a place to come to get resources at no cost if they're growing a business, if they're starting a business, if they're considering a concept. So that's why the center is here, Bill. So I think you've kind of already met Mindy, but she's just really dynamic. Feel free to ask questions throughout the presentation, and I think you'll be really pleasantly surprised with the content. So thank you.
Thank you. Thank you so much, Karen, for the opportunity. I don't know if you guys are in a good position, because I did this last night at 6, or a worse position. Sometimes I go home and I think, oh yeah, I forgot to say this or that. So you get more or less, I'm not sure which. I am Mindy Bickel. I'm the Associate Commissioner for Innovation Development at the U.S. Patent and Trademark Office. I have been in the office since 1989. I started as a patent examiner after getting a PhD in biophysical inorganic chemistry, and you don't have to repeat that. And it was when biotechnology first started as an industry. There was really no biotechnology to speak of when I started in the office in '89, and now, of course, it's pretty much well accepted for medicines and other kinds of things. There was no DNA fingerprinting. If any of you are Dateline or 48-hour enthusiasts, that happened after I started in the office. So it's been kind of fun to watch over the years. As you might have already seen, I have a lot of things that I can share, and I do like to talk. So I'm going to try to stay within the time. I want to make sure that we get to cover all the material that there is to cover. But please do feel free to ask questions. So what I'm going to cover is an overview of the 4 types of intellectual property. We did kind of go around the room and do a little bit of a check-in, but I don't know if anybody already has a trademark. Anybody? Anybody have a copyright? Everybody should raise their hands. Because as I say to my university students when I talk to them, if you ever wrote a letter to grandma when you were little, you have a copyright. You don't have to do anything to register your work. As soon as you write it, and we'll talk more about that, or fix it in tangible media, you own a copyright. Now there are things you can do to sort of protect yourself a little bit more, or if you have to enforce your copyright to make it more advantageous to yourself, but you have a copyright. There's also trademarks, copyrights, patents, and trade secrets. I'm going to go through a little bit, if I can get to it, the process of filing patent application. I'm on the patent side. It's my favorite thing to talk about, but they put it at the end, and I have so much stuff to talk about before we get there that I might not get to the nuts and bolts of filing and the examination process. But my office runs what we call our Pro Se Assistance Program. Are there any Latin scholars in here? Anybody know Latin? I usually have one in every room. Pro se literally means, I believe, by himself. We'll say by yourself, so we'll make it gender non-specific. And it means that you're going to do the application without an attorney. So just like you can file your taxes on your own, or you can use an accountant or a tax attorney, you can file a patent application on your own. You can file a trademark application on your own. And if you do that, you would be called a pro se applicant. So we run the Pro Se Assistance Center. What you can do with my office is call us, email us, or actually make an appointment and come in and sit down with us with whatever it is that you've got, as much development of an invention as you have. And we'll have one of our experts, so it'll either be a real-life patent examiner or a real-life supervisory patent examiner. Will sit down with you and walk you through what you need to have. They will not tell you whether your invention is patentable. The only person alive who can do that in this country is the patent examiner assigned to your application. What they can do is tell you things that you might want to do before you spend the money to file to make sure you have a good chance of success. And we spend an hour, 2 hours, sometimes 3 hours. I think there have been occasions when it's 4-hour marathon to really go through everything that you want to talk about your application. We do ask you to make an appointment, and we do want our people to be able to go home at the end of the day, so we'll cut you off at 4 or 5, depending. So don't try to arrive right at 5 and think that we'll sit down and spend a long time with you, because we want our folks to go home. But our office will do that with you. I'm going to skip this slide just for a second, and we're going to come back, because that slide is a really kind of handy-dandy cheat sheet. You have it in your packet, but if I stop on it, we probably won't get too much further right now. And I cite the Constitution here for copyrights and patents. There's also a constitutional basis for trademark law, but we never talk about the Constitution much, right? I mean, you probably sit down with your friends and say, hey, let's talk about the Constitution for a second here. And it's a pretty amazing and important document, so I like to start with it, because that was really that's where patent law comes from, or the patent system, actually. It's from Article 1, Section 8, Clause 8 in the Constitution. which gave Congress the power, I'm gonna read it, because I haven't done this talk in a long time, so I don't have it memorized as much anymore. It said, Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that's both patents and trademarks. It's the inventions or discoveries and writings. And the things to really remember in there are limited times. So you might ask me later, can a patent be renewed or last forever? No, because the Constitution said it's for a limited time. Now, Congress has passed laws that say what that limited time looks like and is. This is for both patents and copyrights, but it is a limited time. And there's a good reason for that. And the other thing to remember about the Constitution is it said exclusive right. So for both patents and copyrights, you are given the right to exclude others from using your property. You are not given the right to use it yourself. Also a good reason for that, when we talk about patents, or I'll give you the example now, if you invented a chair and you patented it, that's great. You said, without wheels, that chair is too tough to push back. So you put wheels on the chair. You improved his invention. You also can patent that because you improved it. You can't be given the right to use your invention because you'd be infringing on his. So you have the right to exclude everyone from using your chair patent. You have the right to exclude others from using the chair with the wheels. Okay, but neither of you is given the right to use it. That's something that you have to determine for yourself, that you're not infringing on somebody else. Same thing with copyrights. It's an exclusive right, both of those, okay? What else do I want to say about the Constitution? And the other thing to remember, yes ma'am?
Can you explain what you mean then when you say that you're not giving yourself the right to use it either?
So you don't have the right to use it only because you may be able to use it. You have to make sure you're not infringing on somebody else's work. So if you're looking at a copyright, and copyright is, kind of literally the right to copy, reproduce your material. If you have embedded in your novel a song, lyrics to a song that is copyrighted, you can't reproduce that without permission from the owner of that song lyric. So you don't have the right to reproduce your novel with the song lyric unless you get permission, because you'd be infringing on the song lyric owner's right. Does that make sense?
So that would be true for quotes as well?
Yep. You should get permission if you're going to reproduce it. I'm trying to think of an example.
Joe
Is
Biden.
that a different thing?
So we don't want to talk about anything political today, since I'm a federal employee. I'm sorry, say that again.
I was saying, is it enough to cite it, like Abraham Lincoln said this, quote.
So Abraham Lincoln
Or
is
that-
no longer subject to copyright, or his copyrights have expired because it's author's life plus 75 years.
Right.
So let's say you were going to reproduce, I'm trying to think of some, good morning, trying to think of
Jay-Z.
Jay-Z. Okay, I don't know any Jay-Z lyrics, or like if you, or Beyonce or whoever, I can't think of any lyrics, but if you were going to include that, you should get permission. You should get permission to include that in your novel. Is it enough to just quote it? If you're writing a paper, you can probably just quote it. If you're publishing a novel that you're going to sell, you probably want to make sure you get permission, because they will look to stop you. They could stop you from reproducing your paper. Let's say it's a scholarly paper that you're handing in for college credit, they're likely not going to know that you did that. But if you include it in a novel that you're selling, they probably will discover that you did that, and they will come after you in terms of getting a copyright license for them. So what happens in practicality? Well, if you can't use the wheels, but you've got the chair. You can't use the chair, but you've got the wheels. Well, the smart thing to do would be to license to each other, or come up with some sort of arrangement where you both can benefit. And that's typically what happens. If you've got something embedded in your work, they probably will just want some money. They're probably not going to say, well, no, you can't do it. They'll say, no, you can't do it without paying me. Probably, but that's something for you to work out. Okay? Make sense? Other question? You sure?
I think so, I'm just thinking like if you did like a training manual of some sort or a course, and you were citing, maybe not historical works of art, but like current works of art, or Deepak Chopra or someone who's still alive, like you would need permission from them.
So, I don't want to get too much into those kinds of hypotheticals. Like, you probably want to wait until you have a specific situation. Sort of live with that generality, and as you get to something where you have a specific situation, you probably want to get the answer to that question. I always get reminded, sometimes we start down paths of hypotheticals, and then as we get too specific, as we get more and more specific, it's harder and harder to answer without getting exactly, this is the situation that I want to talk about. So adding little twists, I think, might make it murkier than just saying, understand the generality that it's an exclusive right. So if you are using somebody else's work in your work, you don't have the right to reproduce that, or you don't have the right to practice the invention without permission from the owner of that intellectual property. Okay? Trademarks also have a basis in the Constitution, but not as directly. They come from Article 1, Section 8, Clause 3, which gave Congress the power to regulate commerce among the several states. So there's like among foreign nations, blah, 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 and among the several states. And the reason that's important is because if you have a brick and mortar store, let's say, in Pennsylvania, and you only do business in Pennsylvania, you don't do anything on the internet, and you want to file a trademark, you would do it with the state trademark office, not with a federal office. So to be a federal matter, it has to be among the several states. So states don't like the federal government getting into their business. Nobody likes the government getting into their business generally, but we stay out of state matters, so it has to be federal. And then trade secrets we will talk about. Somebody said they wanted to talk about proprietary information, so we'll talk about trade secrets as well. But I wanted to just get to the Constitution, which is kind of the basis for 3 out of the 4. And now we'll go back to that chart. Hard to read, so you might want to follow on your own paper. So I said there are 4 types of intellectual property, but I have 5 columns. That's because there are 3 types of patents, even though I only have 2 columns. So this chart is intended to give you a kind of handy-dandy primer about what is protected, what it protects against, the type of intellectual property, how long it lasts, and remember I said that for patents and copyrights, it's a limited time, and then what third-party creators, what kind of protection they have or rights that they have. What do I mean by third-party creators? Well, let's start with copyrights. So copyrights protect your expression of a particular topic or idea or vision fixed in tangible media. Okay? So my federal government doesn't assert copyright, but if we did, we could assert copyright on this particular explanation as it is written here in terms of an overview of intellectual property. Copyright does not cover the underlying concept of intellectual property. So if you wanted to give this talk yourself, you can actually use our slide because we don't assert our copyright. But if we did, you could do your own chart and put your own words in there and your own explanation of this overview of intellectual property, and you would not be violating our copyright. So you as a third-party creator have full rights as an independent third-party creator. So, like I said, if we were asserting copyrights, you can't use this particular expression, but you can come up with your own, okay? And as I mentioned to you before, I can't remember your name. Dawn. So the term of a copyright is the life of the author plus 70 years. Now, so Abraham Lincoln, you can, yeah, he's not gonna, his estate, if there is still one, his heirs, whatever there is, they're not gonna come after you because his copyrights have long expired. And we like Abraham Lincoln because he's the only president that ever owned a patent, which makes him, to us, pretty cool. And he also said about the patent system that it adds the fire of genius to the fuel of interest. So he was a big proponent of the patent system. So thanks for bringing him up. Copyrights, I find interesting because remember the Constitution said limited time for how long your property rights last. And copyrights and patents are monopolies, right? And this country generally doesn't like monopolies. You know, the Justice Department will break them up. You hear things like that in the news. But the framers thought it was important enough to promote the progress of science and the useful arts to give creators a monopoly for a limited time. So in the 90s, probably some of you remember Sonny Bono, like me. So he was Sonny and Cher, and then he was a congressman. And he authored an extension of the Copyright Act to lengthen the term in order to protect Mickey Mouse, which was about to come out of copyright. And I think there was some talk, I haven't followed it recently, but there was some talk of extending it again. And it makes me wonder, you know, where is limited time, and are we getting away from the intent? I'm obviously not on the Supreme Court, so I don't get to say whether we're getting it away from the intent of the Constitution and saying limited time. Why does it say limited time? Why do you think the framers wanted to limit? We didn't talk about patents yet, but just thinking about copyrights. Any guesses why the framers said it's limited time? It's not going to last forever.
Capitalism.
I'm sorry, say it again?
Capitalism. That's
Mhm.
enough.
Capitalism, but another way of saying that is in the preamble of that clause, Article 1, Section 8, Clause 8, to promote the progress. If somebody came up with a discovery and it lasted forever and no one could ever use it, you could never build on it, you could never use it for anything, we wouldn't really be promoting the progress of science and the useful arts. Part of the reason the framers thought it was important to include in the Constitution is because otherwise people would use trade secrets more. Trade secrets can be a really important part of your portfolio. And here again, third-party independent creators have full rights to a trade secret. So why is that? Well, let's talk about what a trade secret is. Last night there was a can of Coke sitting on the counter. I think everybody, or almost everybody, is aware that the formula for Coca-Cola is a closely held trade secret, right? Nobody's been able to discover that. But if somebody did, they could use that formula and they could sell Joe's soda however much they wanted to, because they came up with that formula independently. They could reverse engineer it and use it. So you could buy a can of Coke. If you are the one who can go home to your kitchen tonight and figure out what the heck is in there and how to make it exactly the same way that Coca-Cola does, you can sell it and they can't stop you. How they can't stop you is there was a secretary to the vice president of product development at Coca-Cola who became a disgruntled employee. And she offered for sale to Pepsi the formula for Coca-Cola. So you can't get it that way. That's criminal. And Pepsi didn't want to participate in that. That would have been a pretty disastrous thing for them to do. So they contacted, I believe, the FBI, and there was a sting, and she did actually serve jail time, that secretary, along with, I think it's her boyfriend and his sister, or her brother and his girlfriend, something like that. And I've often thought must have made for an interesting Thanksgiving dinner after that happened.
So you say it is legal to reverse engineer
Absolutely.
a trade secret. Okay, I've never made it through like an agreement of usage for like PayPal or something like that. Although I've seen frequently as I'm reading through skimming that you agree not to reverse engineer. Is that how you protect trade secrets? in that you require some kind of electronic signature or physical signature that says in order to use this, you agree not to reverse engineer it.
So you raised a really good point. So you could do that, but trade secrets, we haven't talked at all about enforcement. And one of the things that I mentioned last night is, I'm gonna go off on a little bit of a tangent and come back to you. Patents and trademarks are administered by the U.S. Patent and Trademark Office, and copyrights are administered by the Library of Congress. And I say administered because that's in contrast to an enforcement agency. FBI is an enforcement agency. We are administrative agencies. We administer the laws. We make sure that you are entitled to the intellectual property rights that you are applying for, and then we grant you your rights. Basically, we don't really grant you your rights because you're entitled to those rights unless the administrative agency determines that you're not for some reason, and then we have to tell you why and give you a chance to perfect it. Okay, so we don't enforce the patents or trademarks or copyrights. There's no government agency that administers the law with regard to trade secrets. That's all up to you, and it's handled through contracts with your employees. So you have non-disclosure contracts with your employees. You have NDAs with your partners, your suppliers. You have to take a lot of steps to make sure that you are protecting your information. So I like to use the example of my sideline. My hobby, my passion in life is knitting. I love nothing more than knitting. It's wonderful. It's yarn. It's fabulous. You can't have too much yarn. I know you guys probably think it's weird. I don't care. I love it. And I teach knitting on the side. Okay, so a good example of a trade secret in everyday life, not necessarily Coca-Cola, I teach. I have class lists. I have email information and lists of people who have taken my classes. I can hold that as a trade secret. And basically I do because I don't share it with anybody. And you know, so that might not seem a big deal to you, but let's say I was like a really big name in knitting classes, which I'm not, but people might want to know who takes my classes and contact them because they have a competitive class that they think these people might want to take, and that has value. Also in the knitting world, we talked a little bit about this last night, yarn colors are huge. It's, you know, back in the day you were just like, you know, some boring regular colors, and now people dye yarn, and their dye formulas are probably held as trade secrets. Now, you know, I don't, you know, make my husband sign an agreement that he won't look at my computer to get my class list or anything like that. And you could probably easily discover who's taking my classes if you look online and see where I'm going to teach, and you hang out in the parking lot and write down all the license plate numbers from the cars who park. Like, you could pretty easily discover that. You probably wouldn't bother to because I'm not making enough money to make it worth your while to want to, you know, conduct that espionage. But if I were, you might. And then I might want to hold that a little bit more close to the vest and take other steps. Because if I don't, and somebody starts using my class list, if I try to sue them, their defense is you didn't take any steps to safeguard that information. So I had no problem discovering it. Okay, so did I answer your question? Yeah. Okay, so that's copyrights and trade secrets. Now we're going to talk about the ones where third-party creators have no rights at all, and those are patents and trademarks. So, again, back to our monopoly story. There's three types of patents. There's utility, there's plant, and there's design. Utility and plant have some similarities, but frankly I don't talk much about plant patents because unless you're in agriculture or horticulture, you don't really care about them or know about them. But some of those beautiful flowers that you might buy from a florist or in a greenhouse, those are plants that have been asexually reproduced, and through whatever means they use, and I don't really know how it works, they come up with these beautiful hybrids and these unusual plants that are not found in nature, and they patent them. And we all get to enjoy them. And if you ever come to our campus, we have a quad out front of our buildings that kind of acts like a living museum to plant patents, because there's different plantings and there's little plaques that have their patent numbers beside them. So that's really the extent of what I know about plant patents, other than the fact that they have the same term as a utility patent. So when I say the word patent, what most people think of is a utility patent. This is a clicker. I'm gonna look to see if it has a patent number on it. It doesn't. Let's see if I can find something that has a patent number on it. This probably does somewhere on here have a patent number, but I can't see it right now. For sure, the Dell computer has patents covering aspects of it, might have a patent number on it that we can see or not. The equipment in the back, the phone. A lot of times you'll see on different items that there's a patent number related. Those are typically utility patents, okay? So a utility patent covers something that has utility. It covers a process of doing something. It covers a machine that makes something. It covers something that's made, or a composition of matter. So what's something that is made? This was made, okay? This is kind of a machine, but it's something that was probably made by a machine. It wasn't made by hand. Composition of matter, it's like a drug would be considered a composition of matter. And you can also patent processes of making or using something. So if you have a drug, a new drug that's patented, you can also patent the process of using the drug, the process of making the drug. There's probably other processes you could patent. So people sometimes think, oh, well, the patent term is supposed to expire, and yet this patent seems to be going on forever, particularly with drugs, because there's a lot of money to be made from, I should call them pharmaceuticals, from pharmaceutical patents. And what happens is companies will file an application that includes everything, and then they'll pursue one part of it at a time and refile on the rest. So they are now using up their patent term by doing that, because the grant lasts from the date of filing until 20 years from that date. It used to be that a patent term was 17 years from the date of issue. So people would, I don't want to say game the system, but they could have been considered to sort of game the system by extending out those other pieces of that original patent application, and then their patent would issue and they'd have another 17 years. And Congress changed the law in part. There were a couple of very famous cases that were considered egregious, and we would call them submarine patents. So these patents were all confidential. They were not public until they issued as patent grant. And so there were these industries where companies would keep their patent applications going under the surface. So that's why we call them submarine patents. Whole industries would grow up, and then suddenly this patent would surface. And the patent owner could go to all of those industries and say, you have to stop making whatever it is, you have to stop selling whatever it is. Caused great economic instability. And so Congress in 1999 said, no, we're not doing that anymore. What we're going to do now is in 18 months, we're publishing every application. So industries can see what might be out there coming up, and they can make some intelligent, educated decisions about where to invest their money in manufacturing plants or marketing or building up their infrastructure, knowing that this thing may issue at some later point. And the other thing that they did was to say the patent term is no longer from the date of issue, it's from the date of filing. So you, applicant, you need to make sure that you're moving things along so that you get to enjoy as much benefit as you can from your patent term. And you, patent office, need to make sure you're moving the applications along timely so you're not wasting applicants' time by processing delays internally. Okay, so kind of on both sides, now we have an incentive to move things along and get things out there. And why is it important for you to have as long a patent term as possible? That's because that's the time when you can actually stop people from using your property. So as soon as you file, and we'll talk about, there's a pre-filing application sort of that you can do. You can use patent pending on it. You can put people on notice, I'm going to exercise my exclusive rights, you public people that might be using this thing, once my patent issues. I can't do it until the date it issues. But I'm telling you right now, I'm going to have my cease and desist letters ready for you as soon as my patent issues. So you're putting them on notice by filing, by having the patent pending. And that can be useful too. It's useful to the public because they know, well, you know what? I better not build that factory I was going to build. Unless I can reach an agreement with the person who's going to own that intellectual property, I'm going to have to stop it when there are patent issues. So I'm aware, I know, and I can make some good decisions. Utility and plant patents, what the patent protects against is somebody without your permission making, using, selling, offering for sale, and now importing it. It didn't used to be imported. We know with the internet, right, I've been doing this talk for a long time, since before there was really an internet. But now with the internet, our patents issue online every Tuesday. Every Tuesday you can look at our website and see what's new this week, what patents have been granted. And if you're in France, you can go, look at this here thing. I'm going to start making it, and I'm going to put it online, and I'm going to let people buy it. All well and good, but if they try to sell it to people in the United States and you have a U.S. patent, they will be stopped from doing that. Which brings me to the question, where is a U.S. patent valid and enforceable? It's a trick question. In the U.S., there's no world patent, so you have to file in every country where you think you have a market. But for sure, if you have a market here, you want to file here. And it's in the U.S. and its territories. Design patents are a little bit different. So design patents have a different term. It's 15 years from issuance, which is how utility patents used to be. And it's still the same. You can exclude others from making, using, selling, offering for sale, or importing into the United States, but it covers something different. It covers the ornamental look and feel of an object, how it exists in three-dimensional space, which can also be really important to a company. So, and it's distinct from the use of the object. So how this exists in three-dimensional space is this clicker thing. It's got a little bit of a taper, and it's wider, sort of 3/4 of the way up, and then it tapers down again. Now the taper makes it easy to hold in your hand, but as soon as I start talking about how it makes it easy to hold in your hand, I'm back in the utility patent realm. When I just simply talk about how it exists in three-dimensional space, that's a design patent. And to give you an idea of how important that can be to a company, think about if you've ever bought an iPhone, for example, the packaging. Their packaging is pretty crazy. I mean, it's very elaborate, it's very distinctive. It really helps add to their brand, their look, their feel. I haven't looked to see if they have a design patent on their packaging, but they very well could. Another example I like to use is if you guys remember the glass Coke bottle. You kind of don't have to see the word Coca-Cola on that bottle to know that's a bottle of Coca-Cola because the look is so distinctive. And they could have a design patent on that too. So it's how things look in three-dimensional space. The ornamental look and feel. Okay, so we've covered that. Trademarks. Trademarks are super important. Trademarks are what tell the consuming public the source of a good or service. So they cover, obviously, both goods and services. So technically, if we want to cover a service, it's a service mark, but people use trademark now interchangeably, so we're just going to talk about them all as trademarks. But when I say service, I mean let's think about those brown trucks who are driven by people wearing brown uniforms, who get out and put packages on your front porch. You know exactly who I'm talking about, don't you? Their branding is very strong, and they are a service, not a good. They provide a service. You have a dry cleaning business. You provide a service. You can trademark that. And people do want to know the source, right? And there's also, again, no third-party rights to independent development. So if you wanted to start a delivery service and you said to yourself, well, you know what, I like the color brown also. Their brown is kind of like a milk chocolate brown. I'm going to go with really super dark chocolate brown because I like dark chocolate better. I can do that. And yet, your delivery service, you kind of throw the boxes around and half the time they're not delivered. That would really hurt UPS's brand because people looking at those two trucks probably wouldn't be able to distinguish, oh yeah, that's a little bit darker than the UPS brown, so it's probably a different company. So you would not be allowed to trademark something that is similar to a mark that's already in use. Now, one thing I just alluded to is colors can be trademarked. It's not just words. You can trademark a color, you can trademark a fragrance, you can trademark a sound. When you first boot up a computer, there's a sound that lets you know that Intel is inside. I'm not going to imitate the sound, but you all probably know what sound I mean. There's the NBC chimes on TV. If you hear them and you're familiar, I mean, people aren't necessarily so familiar with TV anymore, the original 3 channels, but if you are, when you hear that, you know what that is. You don't need to look at the screen. I think I said you can trademark fragrances. I don't know a whole lot about how you would do that or why, or I don't even have a good example of one. We tried to tease that out a little bit last night, and somebody said Abercrombie and Fitch always has some kind of fragrance in their stores, but I'm going to research that before I do this again. And then, of course, you can use words for your trademark. Trademarks have the advantage that they can last forever, just like trade secrets. Trade secrets can last forever unless they're publicly disclosed. You can have a great run. If you have a choice between a trademark and a utility patent, and you can really guard that secret, you can actually hold it much longer as a trade secret than you can as a patent. The thing that you have to weigh is if somebody discovers that secret pretty quickly, you are out of luck. Whereas with the patent, you've disclosed it completely. You get to hold that monopoly for the 20 years from date of filing. And even if somebody else independently discovers it, too bad, because they don't have any rights. So trademarks last until, they can endure forever, as long as they don't become generic, or you abandon them. So what I mean by generic, facial tissue, Kleenex, which is generic. Facial tissue, escalator, moving stairs. That's a trick question. They're both generic, but escalator was at one point someone's trademark, and they allowed it to become generic. How does it become generic? If you walk up to a Canon photocopier and you say, I'm Xeroxing, you're using Xerox in a generic way. If you open up your laptop and you decide you're going to use Bing to do a search, but you say you're Googling it, you're using Google in a generic way. It's a double-edged sword, I think, sometimes for companies who want their name to be sort of ubiquitous for whatever it is, but then they have to take steps to make sure that they're not allowing their name to be used in a generic way. So I suspect Google wants everybody to say Google and then to actually use Google, but sometimes people say, I'll Google that, and then they use a different search engine. That's not good for Google. You may or may not remember, in the 90s, Xerox used to take out full-page ads in newspapers saying, if you're not using a Xerox photocopier, you're not Xeroxing. And so don't say that, because they had to protect their trademark. So that is something that has to be attended to, or you could lose it. And you have to reapply every 10 years, not reapply, I can't think of the word. You have to renew your trademark every 10 years. And so you have to show that you haven't abandoned it, and somebody could say that, or could make a claim that now it is generic, and you should lose your trademark. So I suspect companies like Google are up against that every 10 years, because then Yahoo could say, Google it and come to Yahoo, or something like that. Questions about this?
What about Walmart? They generic everything.
What about
What about Walmart? They do generic with a lot of stuff.
Say more about that. I'm not sure about the question.
I mean, so to me, just what you're saying just brings to mind Walmart specifically because they have generic version products of a lot
They
of
do.
things. So like that means that they're probably at the heels of checking what's going on and
Absolutely.
what comes out and what they can create and make a product out of it.
You are absolutely right. So I'm going to go, I'll go back to pharmaceutical examples again. There are companies that are watching when a drug that's popular is going to come out of patent, and they're ready to manufacture and sell the day that patent expires. And patents, now, I don't want to get too technical on you because I can get, we can go down a whole lot of rabbit holes. So the patent lasts for 20 years from date of filing, except the way the patent fees are structured. So I don't know if you guys know, but your tax dollars do not fund the U.S. Patent and Trademark Office. You might not know, and you might not actually care, but you don't. So your tax dollars don't pay my salary. They don't pay any of our fees for our infrastructure, our employees, anything like that. Our fees are paid by people who apply for trademarks, apply to register trademarks, and apply for patents. And the patent system is much more complex and expensive than the trademark system. And so the way we set up our fee structure is we tried to keep it inexpensive on the front end so people can get into the system, and we end-loaded fees, meaning your patent issues today. In 3.5 years, we're going to tell you you have to pay a maintenance fee to keep that in force. So you have a decision to make then. So there's a fee at the back end. So if you're not making any money from your patent at that point and you don't foresee making any money, you might want to go ahead and just let it go. Abandon. That's something for you to decide. At 7.5 years and 11.5 years, I think those are the time frames, you have more decisions to make and more fees to pay, with the thinking on the part of the office and the system that that's when you're making your money. If you still want to keep that in force, it's because you're making money from it. And so that's our way of saying you should be paying into the system at that end so we can keep it inexpensive on the front end for people to get into it. So, long way of saying, while I told you they're in force for 20 years from the date of filing, they're not if you don't pay your maintenance fees. So Walmart or other companies that make those generic pharmaceuticals or other items, they're also watching to see, did you pay your maintenance fees? Because if you didn't, I don't have to wait 20 years. I can go ahead and start manufacturing now. It's very complex and complicated, right? So I'm just trying to make sure I told you everything I wanted to tell you about this slide, and I think I did. Again, that's why I don't like to leave that slide up at the beginning, because we could spend the whole time on it. So we talked about all of that, the 4 types. And we talked about this. Trademarks can be very valuable. They let the consuming public know the source of a good or service, and that can be really important, particularly at times like you might remember when there was tainted spinach being sold. So if you were a member of the consuming public, you want to know what company is that, and I'm going to avoid them. And if you were a company selling spinach, you want to make sure people know I'm not that company. So branding can be really important. And I gave you the example of Coca-Cola and the trade secret. So their branding is pretty phenomenal, right? I talked about the Coke bottle. You don't necessarily have to see the words Coca-Cola. You see that kind of, that style of writing and the little bit of a wave underneath. You kind of know that's Coca-Cola. Even if you saw it in another language that had letters that you didn't read, you'd know that was Coca-Cola because their branding is so effective. So even if I went home tonight and I was lucky, I have a chemical background, selling my soda, you would be like, no, that is not the same thing. It tastes completely different because their branding is so efficient. To me, Coke and Pepsi are both brown, carbonated, sugary beverages, but people will fight for their right to drink the one that they like. Another thing about them going generic, interesting little fact about Coke and Pepsi, they will send secret shoppers, I guess, to restaurants who sell one or the other. So I think Olive Garden has Pepsi products. I'm not sure about that. But if you go to Olive Garden and your server says, can I get you a drink? And you say, yeah, I want a Coke. And they come back with your Pepsi, they will get a letter from Coke saying, hey, you don't serve Coke, you can't do that. So that person was a secret shopper. Because the server is supposed to say to you, we don't serve Coke, we serve Pepsi, is that okay? Because that's, again, using Coke in a generic way, which hurts that company. I told you up front that you can only register your trademark with the U.S. Patent and Trademark Office if you're using your trademark for interstate commerce. You have to be in more than one state. Pretty easy to do these days with the internet. If you have something to sell, you can easily be an interstate company because of the internet. And if you make something, you can register your product with customs, and they will help fight counterfeits that are being imported into the country, which is a big deal in some areas. This is just an example. Somebody on my staff, I guess, likes NC State, so they put that one up there. Questions about trademarks, and we're gonna move on to copyrights. Yeah.
I'm just gonna go back to art real quick. When
Sure.
you go back to art, how do you protect it first? And then when I'm watching you do this, it seems like you do more than one thing. Do you copyright it first? Then if it would go to print like a book or a coloring book, how do you protect yourself from someone taking it apart and reassembling it and selling it?
So that's all copyright. So what I didn't say when we had the chart up there, and I'm gonna put that back up for a minute, is what we like to tell people is that they should think about, or could think about intellectual, where did my chart go? There it is. They could think about intellectual property holistically. You want as much protection as you can get on your product, service, business, whatever it is. So if you can find a way to protect what you're working on through all of these different things, you might want to think about doing that. I will say, because we're federal employees, we're not allowed to advise. That's the job of an attorney that you hire. We can't advise you. So I can't tell you what you should do. I can tell you what you could do or what other people do. So your example, that's all copyright. It's all copyright. And they can't take any component of it. You do not have to put the C, let me go back to, I think we were just about to get to copyrights. You do not have to put the C symbol, the C in a circle. You can use it, but you don't have to. And you don't have to register your material with the Library of Congress to assert your copyright. Now, if I were going to write something, I would put the C in the circle, and I would say, all rights reserved. I would put the date and my name. So I do have material that I have done for workshops that I teach in knitting, and I did do that, because I don't want, people are going to take those home. They're going to do what they're going to do, but I want them to be aware I'm asserting my copyright. So if somebody takes it home and they give a copy to a friend, I'm probably never going to know. But if they start using it for a class and it's wildly successful, I might know. And I might be able to do something about it. So I did say at the outset, we're administrative agencies, we're not enforcement. Enforcement is all up to the intellectual property owner. Unfortunately, there's no kind of IP police you can call to say, hey, they're stealing my stuff, make them stop. The way to do that is through a court proceeding. And you can hire an attorney to help you with that. It can get expensive to hire an attorney for all of this stuff. But that's a decision, you know, that you have to come to. Is this worth it to you? Or do you want to start on your own? You know, send a cease and desist letter. You can probably find an example of one of those someplace online and send it and see if that, you know, starts the process. Sometimes I feel like I'm giving a negative message about it. There are plenty of people who prevail in that arena. So there was a movie, I think it came out in, I'm going to say 2007 or 8, called Flash of Genius. It must have been 2008. Because I remember I was doing outreach for the office, and I was on the road in West Virginia, and I went to see that movie. I was the only person in the theater. It's about the patent system. So this guy in Michigan developed the intermittent windshield wiper. So whatever, I can't remember his name, but whoever he is, you should thank him whenever it's drizzly, because he invented it. And he took it to Ford and said, hey, I've got this great invention. I want you to license it from me. And they were like, well, we're not going to license. We don't want to keep paying this guy. We'll buy it outright. And he didn't want to do that. And so they parted ways. And not too much longer after that, he and his family were out driving around on a drizzly day, and he saw cars from Ford that had an intermittent windshield wiper. So they made companies, and I'm not going to pick on Ford, companies sometimes make a strategic decision about whether they're going to steal it or whether they're going to pay for it. And if they steal it and they get a cease and desist or a court action, and again, I'm not picking on Ford, but they will make a strategic decision about how do we want to deal with this? Do we think we have a good chance of invalidating the patent in court? So we're going to do everything we can to invalidate that patent. We're going to spend our money that way because it seems cheaper than having to pay what we would have to pay for this invention. So, you know, that's kind of the dark side of the whole thing. The positive, we'll end on a positive note with that story about Flash of Genius. He sued and he did win. It took an incredible toll on him, and he sued on his own. He did not have legal representation, but he lost his family in the meantime because he was so obsessed, which is totally understandable. It was his, and they took it, and they shouldn't have. So, you know, you like to think that companies and people always do the right thing, but we know they don't because we do have police and criminal courts, and we know that people don't always do the right thing. So, long answer to your question. It's all up to you. You can register with the Library of Congress. So if you write a book, you can actually go on the Library of Congress website. You can download a form. I think it's pretty inexpensive. The last time I checked, it was like $30 to register. And you send them your material and your registration form. And that actually has advantages, which I think might be on the next slide. Nope. But if you do have to sue, it's advantageous to you to have deposited or registered with the Library of Congress if you have copyright. So people in the art world, that's something to keep in mind. And again, your copyright protection happens as soon as you fix that thing. It can be a painting, a photograph, a score of music. It can be choreographic descriptions, however they do that, architecture, drawings or designs. It can be anything that can be fixed in media. Questions about copyrights?
I have one. So, as a librarian, I've been told, like, there's like this little checklist to see if someone is going to be violating copyright. Like if a teacher wants to use a
Fair
small
use.
piece of,
Yeah.
fair use, thank you. So, as I understand it, it's like you have to use a certain percentage or less of the work. It has to be for an educational purpose. You can't make money off of it. Is there something else in there?
You know what, I haven't looked at fair use standards in a while, but that is true. So there was an exception made for education. Because otherwise, there'd be a lot that's precluded from the system. And if you're using a small portion of a textbook, like a paragraph, and you're handing it out to your students, you're not charging them for it, you're just using it to teach them a small portion of information, you are actually allowed to do that. Because again, copyright is who has the right to copy, essentially. But you want to make sure you look up, I would look up fair use regulations before I attempted to do that. But again, it's about, why do we care about all this? It's about making money. Who's making money off of your work? So if a teacher is using it for, a 6th grade class, they're not making money off of it.
I think that the problem with that though is that there's a lot of kids doing projects and they say, oh yeah, go find your images on the internet, but they need to be taught as well that those are only allowable, that particular usage that one is allowable while they're in school under that fair use, but when they go and grow up, they have to be reminded that now you're under a different law.
That's something that the school librarian will teach them if the school has a librarian.
Unfortunately, I think not all schools have librarians like that, but there's a lot of issues around that. I mean, I remember I talked to a freshman class years ago in Wisconsin, and we were talking about trademarks. And at that time, so I lived in New York City in the 1980s, and there were those, generally they were guys on the street corners with tarp out and Rolex watches and Gucci purses for $10. And of course they were not real, they were counterfeits. And I remember this student, and I said to the student, this sounds harsh, but it's true. Those purses and watches, that's part of a criminal enterprise. And in fact, they've been traced to funding for drug cartels and terrorism. So at the back of that, there's some pretty nasty stuff going on with those counterfeits. And the laborers who make them aren't treated well either in whatever country they're being made from. And so I always say that you need to know that you're violating intellectual property rights when you buy that. And I had a student raise his hand and he said, well, I'm morally opposed to spending $3,000 on a Gucci purse. And I said, well, then don't buy one. Just don't buy that. But don't buy that either. That's illegal. You can be morally opposed to whatever you want, and you should use your dollars to, speak with whatever opposition you've got. So don't buy the $3,000 one, but don't participate in this criminal enterprise either. So it's interesting what young people's minds, I think, how they work. And of course, I probably thought those things before I was aware of any of this as well. So we got off on a good tangent, and I don't remember where it started. Okay, other questions about copyrights? Then we'll go back to trade secrets. We talked a little bit about trade secrets. The things to remember about trade secrets, it's all up to you to make sure you are taking steps to protect your secret. Because if you don't, it is vulnerable, and you can lose it. And so somebody could use it, you could sue them, and you could actually lose it because they could use as their defense that you did not take adequate steps to protect it. So, if I had that class list that I was talking about and I really wanted to protect it and I left it out on the table as I was preparing to teach a class and students were wandering in and could just look at it, I've taken no steps to protect it. So I can't really then assert in court, no, that's mine and nobody else can use it.
And we talk about that.
Sure.
How do you then teach a class and not have it be able to be reproduced?
Right, so again, my class list example is probably not the strongest one because it is pretty easily discovered.
Your class list, but anything that you would teach or do in class,
like the structure, right, they have all the processes that go into that. Someone pays and goes to a class, it's discovered.
So that's not a trade secret. So my class content, I would never want to try to hold as a trade secret because it's out there. So I could copyright it. Thank you for coming. I could copyright my class materials, and I could use a trademark, which I do have, to cover the name of the class, to try to create some brand awareness and, have people want to take that content with me. But the class materials themselves, that would be copyright. But again, the underlying concepts are not protected by copyright. So somebody else could teach a similar class, and all I could do then was hope that my branding and my method of teaching was appealing enough that people would really want to just come and take it from me. But you raised a good point. These are just some examples of things that you could hold as a trade secret. And we did talk about this, reverse engineering and independent development, 2 easy ways for you to lose a trade secret or inadequate steps to prevent disclosure. I've said this before, that you want to think about intellectual property protection as kind of an umbrella, and you want to have as many different types of protection on a single item as you can. So think about that in terms of what you have. Are there other ways that you could think about protecting it? And here I just give some examples of all the different ways that Apple has protected the iPhone.
So when I see that, I think about, like let's say attorneys, in reference to you filing it yourself, like you said in the beginning. An attorney would probably say, okay, well, you have something like this, I'm going to charge you $100 grand. So would you say that doing it yourself would save you, let's say 50 grand of that money, doing it yourself? For something like that, let's say, to that capacity.
Yeah, this would be pretty expensive to file. So the real expense is in filing a patent application. So I would say you could count on about $3,000 all told without an attorney, and it could be between.
I just gave you, this is a hypothetical example.
I'm sorry?
I was just a hypothetical example.
Yeah.
I wasn't using real numbers. That was just.
Yeah. So the real expense in filing typically comes from attorney fees.
Yeah.
But they can also be really useful because let's say you go in and you think to yourself, well, I got a phone, I'm going to do a utility patent. It could be the attorney who asks you questions that makes you think, well, maybe there's a design patent in here too. Maybe I do need to think about my trademark. The other thing to think about with an attorney, if you file as a pro se applicant, you don't have an attorney for a patent. Our office will give you a lot of extra help. Our manual patent examining procedures tells us that we actually have to write an allowable claim for you. We didn't even talk about claims, and I'm not going to have time to, but that's really the heart and soul of the patent application is what it covers, which is what we call a claim. So we'll write that for you, but what we can't do is what an attorney might do, which is think about, is that patent going to really, is that claim going to really help you launch your business and cover what it needs to cover so that someone can't easily invent around your patent application and do the same thing you're doing while not really violating your patent. And if you get sued for infringement or need to sue somebody for infringement, what does your record look like of the prosecution of that application in our office so that down the line in court, you have the best chance of winning that you can have? We don't have the expertise to think about that, and we're not going to. So if you have, I always like to say, if you have something that is not commercially valuable, and 97% of patents that are issued are never commercialized. So if you have one of those, you do not need an attorney. Because you're not going to be making money, nobody's going to infringe on you, and you won't really probably be infringing on anybody else. But if you have something, if you're one of the 3% that is commercialized and you've got one of the blockbusters, you can probably count on somebody thinking that they're going to do a slight variation that end runs you. And then you have to decide what you're going to do about it. And you would likely end up in court unless you're lucky enough to just kind of do a licensing agreement. So there is value in paying that money. If you can't afford an attorney, if you make less than 3 times the national poverty level, and it depends on what that number is depends on whether you have a family, blah, blah, blah. You can qualify for the pro bono program, which I think is based in Philadelphia for Pennsylvania, and they will connect you with an actual patent attorney who will provide their services for free. You would still have to pay our filing fees. The attorney can't pay that for you, but you would get full freight legal service from somebody who might charge as much as $300 or $500 an hour, and they will write your application, they will respond to office actions, etc. And a great story about that is the first pro bono program that was set up was in Minnesota. The first person through that got a patent issued is for an item called the cheetah, which helps hang doors. And I don't really know much more than that, but it helps hang doors. And it's supposedly for people who do that, it was a great thing. And that inventor got a 6-figure licensing agreement and went on to create other inventions, hired a staff of like 18 people, and is using the same attorney that gave him free services for that first one and now paying full fare for her charges on his subsequent inventions. That's really the promise of that pro bono program, is that you're gonna, create something, and we, the patent system, the patent office, we want to see your innovations out there. It helps the world. These are life-enhancing or life-saving creations that might, languish on the floor, but for somebody's ability to hire an attorney who can help them. So we're big proponents of that. Long answer to your much that you didn't ask. So we talked about what a patent is already. We talked around this, but clearly patents protect inventions, and it's, remember from the Constitution, the whole point of it is to promote the progress of science and the useful arts. And so there's a quid pro quo, more Latin, which means this for that. The quid pro quo of the patent system is that you get this monopoly for 20 years from the date of filing. You get to make money. You get to say what happens with your invention. You get to exclude others for that 20 years. And in exchange for that, we, the public, gets full disclosure of your invention. So that at the end, Walmart is ready to bing, bang, boom, out with the generic. And then people can also, because they've got full disclosure, they can do research and develop improvements. Most patent applications that we see are improvement patents. It's rare that we get like some new breakthrough. In my time in the office, there have been a few, but most patent applications are improvements. And that's, again, the promise of the system, is that it encourages other inventions. I think we talked about this, but remember, your patent, you can do with it what you would do with other property. You can sell it, you can give it away, you can license it, you can leave it to your heirs if it's still in force. There's a lot that you can do with it. They're a form of property just like anything else. There was a law change in 2011 that said who could apply for a patent. It used to be just the inventor, but now if you work for a company, your company can actually apply. You still have to be named as the inventor, but we call them the assignee. Basically, they're somebody to whom you have assigned rights. So if you join a company, you would probably automatically, when you start your employment, you've assigned your rights to that company and the company will apply. So after you get your patent is almost sometimes the more interesting story than when you're applying and moving through our system. I did talk about licensing. A lot of times that's what happens with your wheels on the chair and your chair. People get together and realize, hey, we can make more money by joining forces than by trying to just stop each other from doing anything. You do have to do your own enforcement. Excuse me. You have to do your own enforcement. There's nobody that does that for you. Just like my example of the Coca-Cola mystery shoppers who try to make sure that restaurants that serve Pepsi don't refer to them as Coca-Cola, you would need to be scanning the marketplace or have people do that for you to make sure that once your product is out there and being used, that nobody is now selling knockoffs of your product without your permission. And of course, you yourself can improve it. And you might decide, you started with 2 wheels, now you might think, hey, I need to go to 4 wheels, and I'm gonna apply for a patent on that. So this was your question. This is the application process. It looks really complicated. Essentially, you apply. So you apply, you just file it, right? It goes through some pre-exam process in our office that just makes sure that you have complied with the formal matters. It's not handwritten. It's on the right size paper. You didn't send in, 30,000 postcards and something like that. So we have some formal matters to get into the system, but then you get to an examiner. That's the person who will tell you whether your invention is patentable. Now, they will look, the statutes all say you're entitled to a patent unless it's not novel. So we're not going to give you a patent on something that's already in the public domain. It's not a discovery. If you decide you've discovered now today aspirin and you apply for a patent, we're not giving it to you. Remember what I said about the Constitution. The purpose was to promote the progress of science and the useful arts by giving you an exclusive right for a limited time. If we now give that right to somebody else, we're taking it back out of the public domain. It belongs in the public domain, right? We don't want to create economic distress and uncertainty. So it has to be novel, it has to be non-obvious. You can't say, well, but I made the aspirin pink. So that's like, now it's new. Or now it's new. It's not, it's an obvious variation. We can dye that aspirin pretty much any color we want, as long as we don't use something lethal to dye it. We're good. So, non-obvious, you have to fully disclose. Remember I said there's a quid pro quo. So the quid pro quo is you get the monopoly, we get to know exactly how to make it, use it, and the best mode. You have a question?
I have a question. So when I was 10 years old, I sent something to, Invent Help or whatever. And I found out 2 years ago, actually, when I researched it, somebody put it together and they're holding the license or patent for it. It's a double-sided toothbrush type of thing. And something he wants like $25,000 to release them. Like, how, yeah, and I'm like, well, okay. Not that I wanted to pursue that, but I was just thinking about it. How does this fall into?
So,
like, how can someone say, well, I put it together, I have a patent for it and everything. If you want to buy my patent, it's gonna cost $25,000.
So if they really are the inventor, they can do that. Now, if you send it to them and you can prove that you sent it to them and they stole it from you, you would have to do a court proceeding to prove that and to recoup some financial compensation for them having done that. Now, I'm not going to comment on any company in particular, but what I will tell you is my office handles scam prevention. And I don't know if your mother's ever told you this, but my mother always said nothing good ever happens after midnight. So if you're watching late night TV and you see somebody offering to help you with your patent stuff after midnight, you really want to think twice before you sign up with them. Make sure you do some diligence. Do diligence to make sure you know what they're going to do for you. Because a lot of times, what they're going to do is file what we call a provisional utility application. It costs you $70. They might charge you a couple thousand. So you want to be super careful because nothing good ever happens after midnight. It really is true. But provisional utility application gives you a year before you have to file the real utility application that gets examined. This provisional doesn't get examined. You don't need to write claims. There's simpler requirements, and it's really inexpensive. It gives you a filing date, because we are now a first-to-file system in the United States. We didn't used to be, but that changed in 2013. We're first to file, so the race to the patent office is important. You fix your filing date for $70. You have a year where you can talk about it. You don't have to worry about it now because you were the first. You got your date. You can do market research. You can look for funding. You can see if anybody's going to be interested in licensing it and might help you pursue the application process. There's a lot of things that you can do that make that really attractive and helpful. So this is the timing, so to speak. You'd file your provisional, application. That is neither examined nor will it ever issue into a patent grant. And then you have 12 months to either let it go abandoned or to file your non-provisional utility application. That application is the one that could mature into a U.S. patent grant, or it could go abandoned if you decide at some point to just abandon it, or if it really is not a patentable invention. I'm going to skip that. Oh, one thing I did say earlier, once you file that provisional, you can use the term patent pending. So you can put people on notice that you are intending to pursue a patent on that invention. I said all that, I think. I'm not going to cover that. Because we only have about 6 minutes left, so I want to make sure I leave the rest of the time for other questions before going down another complex rabbit hole. You do have the information, so all the slides that I skipped, if you have questions about that, feel free to email that email box. If you decide that your question is complex enough that you want to talk to somebody on the phone, you can ask them for the phone number, and they will give you the phone number to call, and we don't have it on the slide, unfortunately. You do have my card. I will not be back in the office for a couple of weeks. My dad just had surgery last week, so I'm going to be up here for a while. So I will not answer your phone call or email for a couple of weeks, but feel free to contact me if you need to. That's my husband, so that's why he's sneaking in. He's here to give me a ride home. But what questions do you have?
Do you have any like general books or other resources that you would recommend maybe having in the library for people just starting out?
So you can get, I think we still will send you booklets about basics on patent filing and basics of trademark filing. You can email that email box. You can email me if you want to, and I'll find that out. And you could keep those pamphlets. They're pamphlets. We don't really recommend books because we don't, we can't recommend anyone's book over any other book.
Okay.
So we can't really do that. But there are a lot of books out there on
I know we
patenting.
have some, like we like the NOLO publications.
Yeah. Yeah. Yeah, but we have some information as well. And we also have, I don't have it with me, but we have a resource list of websites or on our page. Our page is uspto.gov, uspto.gov, like Patent Trademark Office. And there's, if you go to our homepage, there is a, where to start if you don't know anything about this. And there's the problem is there's so much information on there that it can be overwhelming, but there is a lot of information on there.
Okay, thank you.
Other questions?
So as far as the company that I'm working for, we can trademark our logo and just go onto the website and file ourselves.
Yep. It's an electronic filing, and you can do it yourself. I did it myself when I filed my trademark. It can be, I think they're trying to revamp it and make it a better kind of customer experience because it can look a little intimidating. But you can do it yourself. I did do mine myself. I think the thing to watch out for when we were talking, that gentleman at the beginning, he's been getting correspondence that looks official, which I did as well. So after I filed my trademark, I started getting a lot of correspondence that looked official from people who wanted money from me. And it took me a while to kind of figure out which is which. Like, there was something called Patent and Trademark Institute, I think, or I really shouldn't be mentioning their names, but they are legit companies, but they look like they're part of our office, and it's hard to distinguish like what you have to pay for and what they're just offering a service. So that's just something to kind of watch out for. Other questions?
I had a question afterward. That's good.
Sure.
When the recording doesn't go through.
Right. Well, thank you all for coming and
Thank
spending first thing in the morning on Friday with me. It was really a pleasure to speak with you. I appreciate all
Thank
your
you for coming here. Yes.
Thank you.
Thanks for